Hello, Dan Marr here from Hamlin Kerrigan in Nashua, New Hampshire. I'm going to be talking in this blog today about employers, what to do when you get a discrimination claim brought against you. You may have, if you're in business for a number of years, ultimately it will be unlikely that at some point some disgruntled current or former employer doesn't file a claim of discrimination against you in the either EEOC or the New Hampshire Human Rights Commission or both. Usually they're filed as dual companies. If you have 15 or more employees, you're going to be a complaint is going to be filed both in the New Hampshire Human Rights Commission plus the EEOC down in Boston, but the New Hampshire Human Rights Commission is the one that's going to be dealing with the issues on the first front. If you're less than 15, you might just have a claim brought before the New Hampshire Human Rights Commission. But either way, if somebody's saying that you were discriminating against somebody because of the color of their skin, their religion, they have a disability, they're pregnant, their age, a variety of other factors. Gender identity is part of the protected classes as well. You may be faced with a charge of discrimination brought in the Human Rights Commission. You get a letter from the Human Rights Commission that tells you about it, and it does do a very good job in explaining to you the process, that you have a certain deadline to file what's called a verified response, which means it's sworn to as to the facts, as to either agreeing or disagreeing with certain things. It also has some obligations of explaining who's in charge of the company, how many employees you have, and the like, so that they can make some determinations as to jurisdiction within them and or the EEOC in regards to the cases. Those are very, very important to respond to in a timely manner. You might have a situation where you are just so outraged that the claim was so silly, that the allegation by this person was so silly that you're thinking you're incensed that they even bothered doing this. Still take the matter seriously. I have had cases that I'm stunned that even sometimes a lawyer might be representing somebody that just doesn't, the claim doesn't make any sense. It's well worthwhile to spend the time on the complaint, and it does cost you some money if you have a lawyer in regards to it, but spend the money up front because it's a good investment into the case, because if the other lawyer gets to see what's really going on in the case, they may drop it. Or if the person is doing what's called pro se, they're representing themselves in the case in the first instance, they may be shopping around for a lawyer. And if you get a good verified response, an honest one, of course, but with real details in regards to that, and you explain in detail what was really going on, and you provide exhibits of what really was going on, and you do have your lawyer look at it to make sure you're comfortable that you're not opening yourself up for other types of claims out there, and I'll talk to you about that in a moment, then in that situation, it gives the other side, it gives the Human Rights Commission first the understanding of maybe this is not the one that we pay attention to first, and it might be over a year before they actually start investigating that case, because they see, wow, this one doesn't seem to have much merit to it because of everything that you just provided to them. But also when that other person is shopping around for another lawyer or for a lawyer, it's very difficult for them to find somebody because they're going to have to show what the response was. Lawyers, if they are interested in filing a claim for an employee, can remove the claim. They can file the claim with the Human Rights Commission and then remove it, certainly after 90 days, but they can ask for permission beforehand to go to court. And if you have a weak claim there, you probably want to discourage the other side from going to court in regards to that claim. And you want them to just sit there in the Human Rights Commission until they eventually get to it. And it just frankly dies of inactivity, because once they eventually get to it, the investigators do their job, and I find them to be extremely competent in the Human Rights Commission and the EEOC, but they do their job and they see that the case isn't worth something. So it doesn't go anywhere. It takes some time, but not much effort after you've done your initial verified response. I frankly find it similar to what I'm seeing in the current administration of what they're dealing with the CIA and the likes, when they're finding out bad things of other nations they're doing, and they're being public about it. That fresh air of letting everyone know what's going on and what you have and what you've learned about is very helpful, and it's not being playing a game of poker in regards to this makes sense to you and it saves you money. If you have a claim, also check to make sure you don't have what's called Employment Practice Liability Insurance, EPLI. So if you have EPLI, you want to let your insurance company know immediately about the claim, and they may hire their own coverage counsel, or their own counsel to protect you in regards to that claim. And their insurance defense counsel, they're called coverage counsel, is the ones that will actually challenge whether there's actually insurance coverage for you on that claim. But in that situation, if you have that counsel, they may hire that person. There might be a large deductible. Sometimes employers have $50,000 worth of a deductible on employment practice liability insurance just so they can afford it, and that's not uncommon at all. In that situation, you might be able to pick your own insurance company, and I've been picked sometimes, even when there is insurance there, that the employer still wants me to handle the claim for them. So we can do that, and it's very important to go into the details, and an attorney like myself can go into those details with the Human Rights Commission and explain everything, and also explain all the technical defenses too, because there are certain technical defenses that might remove the case completely from the jurisdiction of the Human Rights Commission and or the EEOC, and therefore also in state and federal court. So I'm reachable at 603-883-5501, Dan Marr, 603-883-5501.